If the alarm sounds, trained fire wardens on this floor will direct you to evacuate. You will be directed through one of the 3 fire exits within this room, which are to be used in case of evacuation. At the end of session, please remain seated until the chairman, panel member and the witness have left the room. No photographs are allowed to be taken in the hearing room, and please switch your phones to silent. The toilets, including disabled toilets, are located in the reception area. If you have mislaid any property, please go to reception, where all the lost property is taken. Counselling services are available both in the hearing room and breakout areas. If you have any questions, please approach one of the ushers. Many thanks.
Good morning, everyone. Welcome to today's hearing, at which we're going to hear opening statements from some more of the core participants. And the first person we're going to hear from is Mr. Douglas on behalf of Exova. So, Mr. Douglas, when you're ready, make your way up to the table, please. Thank you.
Mr. Chairman, Madam, I represent Exova and I'm here to provide you with my oral opening submissions. Can I just begin by this, that in your Phase 1 report, you said this: no one who was present at the commemoration hearings or who read or heard their evidence to the inquiry could fail to be impressed by their courage, their resilience and their regard for their neighbours. Together they formed a vibrant community with a strong sense of identity and considerable social cohesion. Exova wholeheartedly agrees with that tribute. And having through a number of senior personnel and representatives attended every day of the memorial hearings found them to be deeply moving and inspirational in equal measure. Exova wholeheartedly supports the purposes of this inquiry and intends to assist it to the fullest extent in this second phase of the search for answers to the many questions which arise. It is obvious that something, or perhaps an accumulation of things, went tragically wrong for a small fire in the kitchen of a relatively newly refurbished block to result within 30 minutes in an inferno 20 stories high, which then wrapped itself around the whole tower over the next 2 hours, causing the deaths of 72 people. It is the purpose of phase 2 to the inquiry to ascertain why this happened. Like others before me, I respectfully agree that until the wide-ranging evidence in all of the first 3 modules has been given, it will be impossible to approach the matter in a holistic way, and that once those pieces of evidence have been given, everybody will be better informed and the whole picture will then be much better understood. Counsel to the inquiry yesterday spoke of the importance of having at phase 2 truthful and candid accounts of what happened during the primary refurbishment so that your factual findings and recommendations may accurately reflect the true nature of the problems. With that, we absolutely agree. Counsel also criticised the corporate CPs collectively for what he described as a merry-go-round of buck passing. It is a memorable phrase, but Exova suggests with respect that any defence or explanation or mitigation of a particular party's actions should not be criticised simply as buck passing. Of course, the inquiry's task is to identify the errors, the wrong decisions that led to the facade being in breach of the building regulations. But if a party has a bona fide defence or an explanation for an alleged error or omission, then it must be entitled to advance it, since the object of this process is to arrive at the truth and to find the real facts on the basis of which reliable findings can be made and important recommendations for the future formulated. Of course, the conclusions to be drawn from the evidence are for the panel, but Exova participates fully and willingly in this process. Its witnesses will cooperate with the inquiry in a truthful manner. The principal criticism of Exova is that it failed to detect or advise adequately on the non-compliance of the proposed exterior cladding system and insulation in the period of its engagement as fire services consultant. However, an analysis of the evidence, which I will take you through in not over great detail, but some, the most striking and persistent feature of the history is that Exova was more or less left out of any communications or information or details of the proposed cladding system. Originally, Exova was appointed by TMO as fire safety consultant, appointed to report to Studio E, as is stated in KCTMO's opening statement. In the early period of the engagement, between August 2012 and 26 November 2012, Exova produced an existing fire strategy, a design note, and issue 1 of an outline fire safety strategy relating to the proposed refurbishment. It needs to be remembered that although these hearings concentrate, for obvious reasons, on the cladding, the refurbishment also involved considerable, complicated work to the lower 4 floors, and that was a vitally important part of the refurbishment and was the aspect of works with which Exova was primarily involved. And just to recapitulate, the refurbishment comprised the creation of a new reception area and office at ground story level, the resiting of a nursery, the creation of new residential apartments in the mezzanine over the ground story, the resiting of the boxing club, the creation of a common community office at walkway level, the creation of new residential apartments in the mezzanine, and improvements to the building services. And these included also a significant glazed atrium type of enclosure to what had previously been external staircases. So those works and the work which was involved in them must not be forgotten. During this early period, Mr. Ashton of Exova was also occupied in advising on and marking up Studio E's general arrangement drawings for the lower floors of the tower, discussing and advising Max Fordham in connection with the extension of the smoke ventilation system to the lower floors, discussing with Studio E the reconfiguration of the mezzanine and walkway levels, firefighting access to Grenfell Tower, means of escape, and attending a meeting with building control. Mr. Ashton was busy in providing a responsive and helpful service. A planning application, an early planning application, was issued by Studio E in August 2012 and revised in October 2012. We know from the disclosed documents that the planning application generated lengthy discussions both internally with KCTMO and with the planners, which were concerned with matters such as colour, appearance, texture, and aesthetics of the proposed new building. Exova was not asked to and did not participate in any of these discussions and was not included in them or in any communications about them. Building regulation compliance is not a planning issue as such, and no attention appears to have been paid to it by Studio E or others involved. The first issue of the outlined fire safety strategy on the 1st of October 2012, produced by Mr. Ashton, provided, by way of introduction, details of the refurbishment being dealt with by Exova, which I more or less recited a second ago. Plus, it gave details of what plans had been considered for the purposes of the report. The report is based upon discussions held with the design team and on drawings numbered, and certain numbers are given, produced by Studio E LLP. It is not disputed that none of those drawings contained any reference whatsoever to cladding. They were what's called general arrangement drawings, and they were concerned with the lower floors. So when, and this is the first time it occurred, Mr. Ashton stated compliance with B4 external fire spread, it is considered that the proposed changes will have no adverse effect on the building in relation to external fire spread, but this will be confirmed by an analysis in a future issue of this report. That would have been understood by Studio E and known because of the drawings which had been referred to and the discussions which had been conducting. That would have been a reference to the works described in the introduction. That was what the report was about. I dare say, as the hearing goes on, there may be investigation of the precise wording of that, but what was being said was perfectly clear in our submission, that these works, which I've considered here with reference to these drawings, do not appear to give rise to an adverse effect on the building in relation to fire spread, but will be confirmed in a later issue of this report. The next thing that happened, more or less on the same day, and which Mr. Hyatt and to a certain extent Dr. Lane lay emphasis on, is that Studio E provided Exova via email with a link to a design team Stage C report. Exova's own report formed part of the Stage C submission. That document said nothing else about it. It was 182, we know now, it's 182 pages long and included a concept proposal originating from Max Fordham, the M&E services engineer, to provide insulation to the building with less depth than rock wool, with the same thermal qualities. Celotex was put forward. This was a very early stage. It was not a design. It's not believed, Mr. Ashton will answer this, but it's not believed that Mr. Ashton operated the link. And there's no particular reason why he should have. He'd completed his first stage report. There'd been no suggestion or conversation with him about cladding. He'd talked to Max Fordham about smoke ventilation. And the fact of the matter is also that that is probably the only reference, not even a direct reference, a reference where you could, if you chose to, obtain some information about one part of a potential very early design. And it's far, far, far too far in advance of the actual choice of the actual system in late 2014 for it to be really causally connected, a failure to do that. And that's what we submit. Almost 2 years before the actual decision for the actual cladding, which was what caused the fire in this case, took place. Then, between November 2012 and August 2013, almost nothing happened which involved Exova at all. This was partly because the planning process was proceeding very slowly, but also because for a significant part of that period, the project was effectively put on hold. This, in turn, was the result of cost issues and the project running over budget. Artelia also were becoming increasingly unconvinced with Leadbeater as a contractor, and there were significant differences between them on the issues of price, cost, and value for money. Although at this stage only embryonically, ACM became a live issue in March 2013, when CEP met with Studio E after discussion with Alcoa, now Arconic, and suggested that there might be scope to switch from zinc to the cheaper ACM cladding option. So for the first 8 months of 2013, Exova were effectively redundant, whilst discussions about cost and appearance dominated TMO's time and thinking, and also Artelia's. One means of generating value or reducing costs was the opportunity for saving money by using a cheaper alternative to zinc. Exova were not involved in any of the discussions on cost or appearance. They were not involved in any discussions about the potential merits of changing to ACM. They were not copied into any correspondence about these matters, nor were they provided with any details about the still early stages of a cladding design. In or about August, or maybe a little earlier, as a consequence of Artelia's and TMO's increasing dissatisfaction with Leadbeater, TMO decided that the project should be put out to tender to select a contractor for a design and build contract. In August 2013, before the tender was drafted, Studio E issued its RIBA Combined Stage D report. This still referred to zinc rain screen panels, but also to folded metal shingles on steel substrate and PIR Celotex FR5000 on existing columns. The reports also included pictures of alternative cladding options, including ACM. The Stage D report was never sent to Exova, nor was any link to the document supplied to Exova, nor is there any evidence that Exova was told anything at all about the proposal for the cladding and insulation system. Over the following months after August, there were a few interchanges between Studio E and Exova, dealing with layout, compartmentation drawing markups, and what it was believed RBKC required to approve the design from a fire safety point of view. There was also a good deal of correspondence with Terry Ashton, Max Fordham, RBKC, TMO about the smoke ventilation system, and those discussions continued into 2014. None of the correspondence involving Terry Ashton contain any details of the cladding design or materials. In October 2013, Exova put forward its second issue of the outline fire services strategy, safety strategy, forgive me. It followed the same approximate course as the one I read earlier, so I won't go, the summary of the refurbishment was more or less identical in this occasion. The plans referred to were slightly updated, but they were still fire strategy drawings produced by Studio E and contained no details of cladding. And exactly the same phrase was again left in the report. It is considered that the proposed changes will have no adverse effect, etc. Again, it was clear that what was being referred to was the works which were being described and the drawings which were being referred to in the earlier part of the report. And we would say that Studio E must have been aware from what is going on and from what it said that that is what was intended. The final issue 3 was submitted on the 7th of November 2013, about 2 or 3 weeks later. And this did have a few changes, but they were more in the way of updating areas of the interior of the building that were being referred to. Again, there was, at the introduction, the proposed development was again referred to slightly differently because some of the details of what had gone on below had altered in the meantime. Again, the report was based upon discussions held with the design team, the Royal Borough of Kensington and Chelsea, and on fire access and fire strategy drawings produced by Studio E LLP. And fire access and fire strategy drawings were not drawings to do with cladding. And then there were some more detail about fire detection alarm systems, means of escape, new stairs, smoke ventilation of lobbies, and again, the exact same expression: it is considered that the proposed changes will have no adverse effect on the building, etc., but this will be confirmed by an analysis in a future issue of this report. So again, we say it was clear what was being referred to. Back to the beginning, the plans and the refurbishment of the lower floors. It was conditional and made it clear that a further report would be expected. But that's subject to various matters to which I shall come in a moment. Now, at this point, I should just mention a point that was raised by Mr. Popat in his submissions yesterday, or 2 points. In relation to the latter document, the issue 3 report, he said this yesterday at page 50, line 14 of the transcript. He quoted it. He quoted what I've just read, and he said, "Indeed, the advice provided by Exova in its fire strategy report regarding compliance with Part B4 was that the proposed changes, that is, the overcladding proposals, will have no effect on the external fire spread." And that is, with respect to him, no doubt inadvertently wrong. That is not what it was saying, and it's not a proper interpretation of the document. He also said a bit earlier, perhaps not as seriously, but he did suggest that in relation to the earlier planning application, Studio E engaged with numerous consultants, including Exova and different suppliers, and none of these consultants or suppliers raised any queries or concerns regarding the brief to overclad the tower. We say that is not right. Studio E did not engage with Exova in selecting materials for the cladding system, was not directly involved in the application for planning permission, and that therefore that too was erroneous. If we then resume the history, very shortly after, almost alongside the Stage D report, a much more significant document was generated, and that was the National Building Specification, which became part of the employer's requirements. And I will, for just maybe a minute or so, or minute or two, refer to what it said. We know that it became part of the employer's requirements for the purposes of the tender. It specified rain screen cladding as aluminium honeycomb core structurally bonded between 2 lightweight zinc sheets. It said that in addition to the cladding specified, tenderers would also be invited to submit comparative supply and install costs for a number of alternative materials: Rainabond Duracloth, Alucobond, quartz zinc composite, and separately the NBS specified thermal insulation Celotex FR5000. And what is also of significance is that it set out a number of general requirements, which included compliance standards, the Centre for Window and Cladding Technology standard for systemised building envelopes, information to be provided during detailed design, proposals to support outstanding applications for building regulations consent and relaxations, and information to be provided before commencement of testing or manufacture of rain screen cladding system, detailed calculations to prove compliance with design performance requirements. Those design performance requirements then again refer to the CWCT standard and said that unless specified or otherwise agreed, they must comply with Part 6 fire performance, which again says, the building envelope shall also comply with building regulations or local building code. The building envelope shall not be composed of materials which readily support combustion, add significantly to the fire load, and or give off toxic fumes if ignited. Then the design performance requirements also specifically required fire resistance of the backing wall, 60 minutes integrity, 60 minutes insulation, internal surface spread of flame of backing wall, class 0, cavity fire barriers to resist the passage of flame and smoke for not less than 30 minutes integrity. Now, the significance of that is twofold, namely that when the tender documents, including this employer's requirements, were accepted by Ryden, who succeeded, they took on these obligations. The second point is also this, and I'm not going further than just to make this point, that these specifications were drawn up by Studio E. And they were drawn up by Studio E without any consultation or reference to Exova. Studio E must have felt that they were sufficiently skilled to be able to put forward a series of quasi-regulatory requirements to support the passing of building regulation approval and to support the necessity of providing calculations and information and details which would demonstrate that the cladding system would comply and not be dangerous. And that is quite an important point when one's looking at the skills of the various parts. SE considered, obviously, that they didn't need or want input from Exova. No questions were asked, no drafts circulated. There was no Exova involvement in the selection of materials. And thus it was that Exova were, not using the word excluded, Exova was simply not involved in that process of drafting the NBS specification, approving it, or making comments on it. The specification was there. In March 2014, KCTMO, having received a number of responses to the tender, decided to appoint Ryden as D&B contractor. This changed the project fundamentally. Ryden, as is accepted, agreed to accept design responsibility for all aspects of the project, including compliance. It entered into a contract which specified zinc cladding with a honeycomb core, provided that alternative materials might be used, but only in accordance with provisions requiring compliance with prevailing regulations and other specific provisions. Pursuant to its appointment, Ryden created its own design team. The design team comprised Ryden plus Studio E, Harley, Curtains, and JS Wright. All of these were now subcontractors to Ryden, to whom they had either been novated, in the case of Curtains and Studio E, or appointed as Ryden's new specialist subcontractors, as in the case of Harley and JS Wright. Critically, Exova were not novated. At an introductory meeting on the 1st of April 2014, Ryden told TMO that it would contact Exova with the view of using them going forward. It never did. Indeed, Mr. Lawrence had told Mr. Soons about a week before the meeting that Ryden typically did not engage fire consultants. He regarded it as building control's responsibility to raise any concerns and satisfy themselves with the details of the submission. And Mr. Crawford recalls Mr. Lawrence stating to him in a discussion about Exova, when Mr. Crawford, I think, had put in a phone call to them, Mr. Lawrence said, "So if you're getting some free advice, then great. Otherwise, we'll need to look at this." It would, of course, have been open to Ryden to seek another fire specialist to advise, but it did not. So this is an important issue, that Exova were not part of the design team after mid-March 2014. Their only function thereafter, whether it was a function, whether it was something simply that Mr. Ashton was happy to do, was to respond to ad hoc inquiries from contractors, or on a very few occasions, Studio E, when they were passing on questions by contractors. After being appointed and after the design team had been established, Ryden, KTCMO and Artelia almost immediately began discussions about saving of money on the cladding if ACM were selected. And a figure of £454,000 was calculated by Harley as the saving achievable for using a cassette ACM system. By the end of July 2014, TMO had decided to proceed with Rayner Bond in, at that stage, a champagne colour. Ryden then stated the full design can now start and the design team meeting should start. Final approval for the new facade with a slightly different colour was obtained in early October 2014. Exova is not aware that any of the design team appointed by Ryden, including Ryden itself, took any steps either themselves or through taking specialist advice to verify whether the detailed fire performance requirements set out in the employer's requirements were being complied with. The decision to design the cladding system that was actually used, using ACM, was taken after Exova had been removed from the design team, and was a decision in which Exova were not invited to and did not play any part, nor were Exova informed of the decision. So in summary, Exova was at no stage involved in discussion or development of the design of the cladding system with anybody in the design team, either before or after the D&B contract was awarded. It was not involved, other than by the issue of its own fire safety strategy reports, in the development of the RIBA Stage C and Stage D reports. For a significant part of 2013, the project was on hold, and Exova was not really utilised at all. Exova was not involved in the compilation or approval of the tender documents of the NBS, was not involved in any design team meetings after November 2013, whilst the tender was awaiting resolution, took no part and was not invited or expected to in discussions about materials to be selected for the exterior cladding, was not novated to Ryden, and was not part of the design team after mid-March 2014, and was thereafter effectively sidelined and did not receive information or involvement about the cladding system, did not select the materials, did not have any say in the design or choice of materials, and was never asked for advice except in very small and specific ways after Ryden became the main contractor and main designer. For these reasons, in summary, we submit that criticism of Exova's conduct is unjustified, and insofar as statements, which, broad shoulders, are described as egregious, are concerned, are simply unjustified. Question of cavity barriers, I'll deal with this very briefly. Exova came into the picture twice in September 2014 and March 2015. In September 2014, Exova was asked by Neil Crawford, pursuant to a request for information from Harley, about horizontal cavity barriers at floor ceiling level, and advised that they were required. That was correct. Mr. Ashton commented, consistently with what we have been saying today, that he'd never seen details of what was being done to the external walls. In March, Exova was asked by Neil Crawford whether the cavity barriers were in fact required to be fire stops, and advised that they were not. That also was correct. Now, quite a lot of mileage is sought by Mr. Hyatt and Dr. Lane about cavity barriers, and I think that it is important just to recollect, first of all, that in relation to the cavity barriers which formed part of the external rain screen cladding system, it was agreed by Professor Bisbee, Professor Torero, and Dr. Lane that if the exterior, if as it were one of the sides of the cavity barrier became enveloped in flames, it would then either bulge or fall away, and the cavity barrier would play no sensible purpose. So far as the cavity barriers around the windows were concerned, Professor Torero, Dr. Lane, and Professor Bisbee all said either that normally cavity barriers were not designed to prevent the egress of fire, and secondly, in any event, they could not see how such barriers could effectively be designed in this building because of the complexities of the way in which the windows were put together. Now, Mr. Hyatt, in his report, appears to suggest, not in these words, that he's cracked it. I don't know whether that, we'll have to look into that. Whether or not anybody at the time of normal skill would have been able to do that is quite a different matter, but we'll have to see whether in fact he's successful or not in what he puts forward and how long it took him to do it, and etc. The history I've given is quite extraordinary, And what one needs to understand, and perhaps, I actually understand those BSR submissions that talk about fragmentation and slipping between the floors, slipping between the gaps. I mean, something has happened in this case to have almost two parallel streams. One set of people talking about planning and cavities and employers' requirement, and another lot looking at the work going on at lower floor levels. But it does seem that in some way, through the fact that the planning application was made and the intense, very prolonged discussion about the appearance of that dominated thought, then distracted by the cost budgets, change of contractor, and desire in some way to lessen the cost even by changing materials, then by the expectation that the new tenderers would take over responsibility of developing the design with its own team, in some way the design arrangements were not properly coordinated. And it is a fact that, and again, I'm not trying to pass the buck, but it's a question worth looking into, is how is it that Studio E never actually said to Exova, excuse me, we're planning a cladding system, would you like, you said you'll do it, we're now about to do it, will you please advise us or update your report? That never happened. How is that? And then when Ryden became involved, we know they didn't prolong or continue our engagement. But how come they went through the next phase without ever saying, hey, we need to have somebody to advise us whether this is, and that didn't happen in either case. Can I finally deal briefly, although I think it could be more of an issue, with Dr. Lane, who's written a 262-page report, so far as I can see, basically dealing with two individuals, one in particular, Mr. Ashton, and the other, Miss Cooney. And we have a number of objections. We've taken some objections in our written opening. And we feel that there are criticisms to be made because her approach appears, although she uses a thing called an FIA template, her approach appears to be not what alternative possible approaches could a competent fire consultant take to some of the issues in this case. Just like in all forms of walks of life, somebody like Terry Ashton is obviously the sort of chap who likes to talk through changes with individuals on the spot rather than writing lengthy reports. There's no analysis of that at all. In fact, what's put forward is what we submit as a slightly dogmatic approach. This is how I do it, and that's what's right. And if you didn't do it, that's wrong. It's also quite theoretical and legalistic. There's quite a lot of law, some of it overt, some of it concealed. Like some of her views depend on her particular view of the interpretation of our agreement. She then, and I know Artelia complain about this as well, I think, expands duties beyond the contract and says, well, nevertheless, you ought to have done this, that, and the other to do with the regulatory reform, fire service order, Regulation 38, even though she concedes that Regulation 38 wasn't expressly addressed in our contract. She fails to deal in a lot of expanded ways about things which could or shouldn't have been done as to whether they are actually relevant to any causation. So we take significant issue with some, and we also take significant issue with that approach, also with the dismissal of the notion that Exova might reasonably expect to be asked to advise, or when the decision is approaching, would somebody please tell me, and then we'll do the report. That she seems just to disregard that on the basis that we make our own scope, and therefore we've got to do what we said without any regard to practicality whatsoever. There's scarcely a passing mention of the fact that Ryden became design and build contractors, and there's scarcely any mention or discussion of the significance of the fact that there was no communication with Exova about the design of the exterior. So we're not going to go further than this today, which is we agree, obviously, that evidence has to be tested, and we're not making any application you needn't be concerned about that, at least for the moment. But we do think that some consideration is going to have to be given to the possibility on our part of seeking to ask questions of Dr. Lane ourselves. But I'm leaving that for today. I appreciate that's not always been popular. But there might be differences. So that, Mr. Chairman and Madam, is the conclusion of my submissions on behalf of Exova.
Well, thank you very much, Mr. Davis. That's very helpful. Now, in a moment, we're going to hear submission, an opening statement by Arconic, but for practical reasons, we're going to have a short break at this point. I was going to say 10 minutes, but that will take us to something like 10:47. So rather than play around with odd minutes, I'm going to say 10 to 11. Right? Thank you very much. 10 to 11, please.
Hello, we are about to resume. Therefore, please can you take your seats and remain silent. May I remind you, no photographs are allowed to be taken in the hearing room, and please switch your phones to silent. Many thanks.
Now, Mr. Hockman for Arconic. Thank you.
In its letter to core participants dated the 30th of October 2019, the inquiry identified compliance as being within the scope of Module 1. Such matters clearly affect the interests of our client, and we have therefore submitted, as you know, a relatively short written opening, which we trust you will have read, and we are grateful for the opportunity to make this likewise relatively short oral opening. This is clearly not the moment, however, for me to outline, let alone give full details of, the evidence which you may hear from persons in our employment at the material time, since such witnesses will be called in Module 2. I am therefore deliberately deferring any remarks which I might make by way of opening in relation to such evidence until the week commencing the 4th of May, which has been identified as the time period for oral openings in relation to Module 2. It follows that I shall resist the temptation to respond to every one of the comments which have been made about our employees by other core participants in their written and oral openings. Since I've just referred to the openings of other core participants, I would like, in these introductory remarks, to add this further observation relating to those openings. Speaking generally, some of those openings share the characteristic that they seek to allocate blame upon others, usually other core participants, as a means of exculpating or seeking to exculpate themselves. Other openings share the characteristic that they complain precisely about the tendency of some core participants to proceed by blaming others. I hope that you will observe that we have adopted neither of these two approaches. In particular, one of the features of our case, which differentiates it from others, is that we do not seek to allocate blame as between others, certainly not at this stage. If there are criticisms to be made, then we have little doubt that your team will be astute to identify them where it considers them to be justified. In the presentation of our case, by contrast, our primary focus will be to identify the role which we play and the limits and parameters of that role. And we submit with emphasis that it is essential for you and your team to understand those limits and those parameters if you are to make a fair judgment in your Phase 2 report as to the acts or omissions of our client. It follows that the first part of these oral submissions will be concerned to identify the role of AAP SAS, whom I shall call the company, acknowledging that we have dealt with this already, not only in our written opening for this Phase 2 module, but in our openings and closings, written and oral, for Phase 1. Given that in this module, as well as no doubt in later modules, the inquiry will be concerned with the regulatory regime which prevailed at the time and applied to the work that was carried out at Grenfell, it will then be necessary for me to make some comments about that regime, about its significance in the context of the role which our clients played. This will form the second and predominant part of my submissions. Then thirdly and lastly, I will discuss briefly how the regime appears to have operated in relation to the works at Grenfell. So I start with a section on the company's role. As we indicated in our Phase 1 opening statement, the company carries on business at Merxheim in eastern France, where it manufactured a range of architectural products, including ACMPE. The company was a relatively minor participant in the UK market, supplying ACMPE for use to a small number of customers within the UK. Comparable panels have also been supplied in greater volume by many others. Indeed, as you've heard, this kind of ACM cladding panel was in widespread use for many years in the United Kingdom and abroad. The position statement by the department noted that advice had been given to owners of 457 high-rise buildings relating to the use of ACM cladding panels. Turning to ACMPE itself, this had been available on the market for many years. It comprises a polyethylene core sandwiched between outer sheets of aluminium. We do say that it would have been obvious to anyone professionally involved in the construction of a building that by reason of the polyethylene core, this product was not of limited combustibility. Now, Module 1 will not be the occasion for detailed scrutiny of the way in which ACM panels were marketed, but it will in due course become clear that the products which were marketed by the company included not only ACM-PE, but also ACM-FR, the FR standing for fire retardant. And this was a further very clear indication of the combustible nature of the PE product. In order for the ACM panels to be attached to a building, it was necessary for them to be fabricated into the desired size and shape, a process undertaken by others following supply by the company. In relation to such processes, we would add the following points. A, the first step in the process is for an architect, designer, or other construction professional to decide to approve the use of the product on a specific project and to determine exactly how it is to be used. It is at this stage that building regulation compliance has to be considered. The next step is to purchase the product from the manufacturer. Then the product must be fabricated by suitably competent professionals into the shapes specified by the designer. Those fabricated panels would then need to be fixed by suitably competent installation professionals and by means of rails or in some other way which would safely support those panels as part of the cladding system. The overall cladding system, which includes the ACM panels as fabricated and fixed to the railing system, as well as the insulation and other materials used on the external facade, should have been designed and installed according to applicable regulations so as to be sufficiently robust to withstand external fire exposure without causing significant acceleration of fire spread or prejudicing the structural integrity of the cladding system. Ultimately, however, specifying the profile, methods of fabrication and installation are matters of choice for those responsible for the design and construction of the relevant building. Now, the last thing I'd like to mention in connection with the company itself is this, that in 2015, the translucent ACM-PE core was substituted with a carbon black core, and that was achieved by adding a small amount of carbon black material to the existing core, which provided greater ultraviolet protection for the core at exposed panel edges. The change was not related to fire performance. Both translucent and black core were to be found at Grenfell, and Dr. Lane actually suggests that the black core may give rise to improved fire performance. That is in her supplementary Phase 1 report in Appendix O. Now I come on to deal with the regulatory regime, and this will be a rather longer section of my remarks. In our written opening, we gave a fairly full description of the relevant regime, including reference to the Building Act 1984, the Building Regulations 2010, and of course approved document B. But let me make this preliminary and rather important point. It's important to remember that the relevant regulatory regime applied to the construction or refurbishment of Grenfell Tower. It did not apply to the sale of one component of the cladding system. Those professionally involved in the construction or refurbishment of a building are expected to ensure that the combination of materials chosen for a particular project will enable compliance to be achieved. The supplier of an individual product would be entitled to assume that this would be done. Now, we have summarized the effect of the regime as follows, and I need to go into a little bit of detail here, as you will see. We have said that the guidance proffers in broad terms two routes to compliance when designing a cladding system. The first is that external walls meet the guidance given in paragraphs 12.6 to 12.9. And paragraph 12.6 suggests that the external surfaces of walls should meet the provisions in what is called diagram 40. Insofar as the external wall is over 18 metres, diagram 40 suggests that the external wall surface classification should be National Class 0 or European Class B. In addition, and of importance, paragraph 12.7 suggests that in a building with a story 18 metres or more above ground level, any insulation product should be of limited combustibility. Now, this route to compliance, the first route, is sometimes described as the linear route. And this is the route which requires the insulation to be of limited combustibility. The second route is that the external walls should meet the specified performance criteria using full-scale test data from British standards. And it is, of course, the responsibility of builders, architects and specifiers on a particular project to ensure that the requisite systems testing has been carried out. Now, pausing there, having mentioned those two routes, we would observe that the linear route to compliance would clearly not have been available here because the insulation was, on any view, not of limited combustibility. In consequence, it follows that the compliance of the new cladding system at Grenfell Tower could not have been determined by the fire rating of any individual product, but had to depend on an assessment of the cladding system as a whole. Those concerned in the design and construction of the refurbishment must have been aware of this requirement. It's a basic element in approved document B, and of the absence, as already stressed this morning by Mr. Douglas, of any such assessment, irrespective of their exact state of knowledge of the combustibility of the ACM panel. I'll just say that again. Those concerned in the design and construction of the refurbishment must have been aware of the requirement for assessment of the cladding system as a whole, and of the absence of any such assessment, irrespective of their exact state of knowledge of the combustibility of the ACM panels. Now, approved document B did not intend the two options which I've already mentioned to be exhaustive routes to compliance with the regulatory requirement B4. Two other methods of compliance with regulations have been recognised within the industry, and that is evidenced by Technical Guidance Note 18 produced by the Building Control Alliance. One of those further routes to compliance identified by the Building Control Alliance in Technical Guidance Note 18 involves a so-called desktop study, but we've seen no evidence that those responsible for the design and refurbishment of Grenfell Tower conducted a desktop study of the particular configuration of ACM material and insulation installed on the building. Finally, the fourth route, finally, in appropriate circumstances, compliance may be shown through what is called a holistic fire engineering assessment. Such an assessment must take into account the design features of the building as a whole, including effective compartmentation, active and passive fire prevention mechanisms, egress options for residents, and more. It is plainly not enough simply to look at the performance of the cladding system, let alone any one particular element in it. Approved document B itself supports the proposition that a holistic fire engineered route is an alternative but nonetheless legitimate route to compliance. It confirms our description as to what was required when opting to employ a holistic fire engineering approach to compliance. And indeed, in some circumstances, this will be the only way to achieve the statutory objective. And in our written opening, I think we quote a paragraph in the general introduction section of approved document B under the heading Fire Safety Engineering, which reads as follows: Fire safety engineering can provide an alternative approach to fire safety. It may be the only practical way to achieve a satisfactory standard of fire safety in some large and complex buildings and in buildings containing different uses. Fire safety engineering may also be suitable for solving a problem with an aspect of building design which otherwise follows the provisions in this document. And I might add that the four routes to compliance that I've just described were recognised in a government consultation paper dated April 2018, the very consultation paper which led to the more recent changes in the regulatory regime of which you are aware. Now, there's no information available that those responsible for the refurbishment of Grenfell Tower employed this holistic fire engineering approach, and indeed the many deficiencies in the building would seem to make clear that no such approach was adopted. Moreover, the inquiry itself, in its Phase 1 report, has found that a functional requirement in the regime was not met. However, as we've already explained, this company's role was essentially to supply a product which required fabrication before installation. It was the responsibility of others to decide whether or not to choose that project for a particular, to choose that product for a particular project, how to specify and utilize the product in the construction or refurbishment of the tower, how to carry out the detailed design, how to fabricate the product, how to fit it to the external surface of the tower, what other components to combine it with, and in every other respect, how to carry out the refurbishment. The regulatory regime, as I've already emphasized, applied to the construction or refurbishment of the tower. It did not apply to the sale of one component of the cladding system. And moreover, those professionally involved in the construction or refurbishment are expected to ensure that the combination of materials chosen will enable compliance to be achieved. The supplier of an individual product not only cannot do that, but would be entitled to assume that it would be done. As I indicated in my earlier introductory remarks, it's not my intention at this stage to address questions such as the extent to which those employed by our client, most of whom were based in France, were aware or could or should have been aware of the details of the regime which I've set out. It was not their responsibility to decide whether the product was appropriate to use in a particular configuration for a particular project. However, a key element in the criticisms made by others relates to the so-called BBA certificate issued to the company in 2008 by the British Board of Agreement, a private sector organisation which essentially provides information about the product to the marketplace. Again, we deal with the BBA certificate in some detail in our written opening, and my task now is to summarise the position and to do so as far as I can in non-technical language. By way of background, a product such as ACMPE could be tested either under a set of national criteria or under a set of European criteria. Of course, we are dealing with a period of time when the United Kingdom was still unequivocally part of the European Union. It's interesting to note that in her written opening submissions on behalf of some of the bereaved survivors and residents, my learned friend Ms. Barwise comments at her paragraph 7.2 that when the European criteria were introduced into approved document B in the year 2000, national class 0 should have been abolished, and that it is an outdated and confusing classification which has created a completely false sense of security amongst industry at large. However, the fact that the two sets of criteria continued to exist The fact is that the two sets of criteria continued to exist side by side, and indeed approved document B, as I said earlier, through the use of a particular diagram known as diagram 40, advises that above 18 metres, the external wall surface classification should be class 0 national class or class B European class. And it was therefore perhaps entirely understandable that the BBA, having before them evidence that the product was capable of achieving European Class B, confirmed that it could also be treated for the purposes of compliance with the guidance as achieving also National Class 0. Now, I hope it will be carefully noted that both in our written opening and in what I have just said orally, we say that the product was capable of achieving the requisite European class, namely Class B. To explain the importance of this, I need to say a word about the way in which a product such as an ACM panel is tested for the purposes of establishing the European class, in particular Class B. It's important to recall, as anyone professionally involved would be aware, that this testing of a product, such as an ACM panel, because that's what was supplied by the company, that this testing of a product is carried out for the purpose of European class testing in the context of a system, and that systems may vary. The fact that under particular test conditions, Class B can be and has been achieved necessarily cannot be a guarantee that Class B will be achievable in any and every set of circumstances. For example, in approved document B itself, in Appendix A, paragraph 16, it is emphasised that small differences in detail, such as thickness, substrate, in this case the insulation, colour, form, fixings, etc., may significantly affect any fire rating. And therefore, this is still quoting from Approved Document B, Appendix A, paragraph 16, therefore any reference to the surface spread of flames should be carefully checked to ensure that it is suitable, adequate, and applicable to the construction to be used. So it will be our submission that the very nature of the testing process makes it impossible for those professionals involved to treat a particular test result as applicable in all circumstances. That is why we use the phrase capable of achieving the requisite European class. Now, against that background, I want to draw attention, again in very general terms, to a further important aspect of the BBA certificate. And I say that the BBA certificate might be described in the context of this case by the phrase much maligned, although one wonders whether the reason why it is much maligned is simply because its contents have not been fully absorbed. Among the points which are relevant to this submission are these: that the BBA certificate certified nothing other than the surface of an unfabricated panel, that it contained a range of appropriate caveats as to the fire performance of a fabricated panel in a particular cladding system. The certificate on its front page describes the panel as aluminium polyethylene composite, which is a clear signal to any professional that the core is plastic and combustible. The certificate is also explicit that the performances which it certifies may not be achieved by all colours, and that in any event it does not apply to the fire resistance of a wall, a complete cladding system incorporating the product, which must be determined by further tests. This is all entirely consistent with what I've said previously about the testing regime. Moreover, the certificate stresses two important things. The certificate stresses that particular attention should be paid to preventing the spread of a fire within a building, breaching the cladding system through windows and door openings, and that cavity barriers should be incorporated. One might say that those who criticise the BBA certificate should instead be acknowledging that it should be seen in the context of the present inquiry as tragically prophetic. It will be apparent from what I've already said, therefore, that a number of the complaints which you heard yesterday are entirely lacking in substance. For example, as already mentioned, it would have been obvious to anyone professionally involved in the refurbishment who read the first page, let alone the full document, who read the first page of the BBA certificate, that the core of the panel was combustible. It would also have been obvious to anyone professionally concerned with fire safety that thermoplastic polymers, such as PE, present particularly challenging behaviour as regards reaction to fire. And it would also have been obvious that different forms of fixing, remember paragraph 16 that I mentioned refers to the form and fixing, different forms of fixing, whether rivet or cassette, might not achieve the same rating, and that specific testing in the course of an assessment ought to have been carried out. Moreover, let me emphasise once again that this responsibility cannot possibly be said to have lain upon the supplier of an individual product. And as to knowledge, without entering into the extent, if any, of our clients' knowledge as to the other components of the cladding system at Grenfell, such knowledge, if any, did not remotely fix them with the responsibility to intervene in relation to the choice of those components and take upon themselves a responsibility which it was for others to fulfil. So we shall in due course be inviting the inquiry to reject any criticism of our client based upon its adoption of the BBA certificate. As to the suggestion that knowing that the core was combustible, we should have attached some form of warning to the sale of the product, we will be addressing in due course more detailed submissions to you on that. Suffice it for present purposes to say, firstly, that under clear authority in this jurisdiction, matters obvious to the user do not need to be warned against, but in any event, the BBA certificate itself was the clearest possible signal as to the features of the product and as to the need for due care to be taken. So I come to my third and last heading, which, as I said earlier, will be relatively brief, and it's just to see how the submissions I've made apply in the context of the tragedy at Grenfell Tower. As we pointed out in our phase 1 openings and closings, and as we have reflected here, there was and still is no evidence that anyone conducted an appropriate fire engineering assessment before deciding to utilize our product in the context of Grenfell Tower in combination with other materials and in a particular format or system. On the contrary, there is now positive evidence, or at least a very clear inference, that any perusal of the BBA certificate, whose content I have outlined to you, was at best superficial and not the careful and holistic assessment which would have led to a very different outcome. The outcome might have been a different choice of material, or it might have been to fabricate and configure the materials in a different way, as illustrated by the Camden example mentioned yesterday by Mr. Laidlaw. Those are our submissions in opening to you this morning. Of course, we look forward to assisting both of you in greater detail as your work on phase 2 proceeds. Thank you.
Thank you very much, Mr. Hoffman. Now, the next statement is to be made by, I think, Mr. Orr, Queen's Counsel, on behalf of Celotex. Yes. Right, Mr. Orr, I'm sorry I hadn't picked up your particular spot in the room, but take your time.
Sir, Madam, I appear for Celotex, together with Mr. Patrick Hennessy. We are instructed by Linklaters. I wish at the outset to reiterate Celotex's deepest sympathy, both to the families of those who lost their lives as a result of the fire at Grenfell Tower, and to everyone who has been and remains affected by that devastating and tragic event. Celotex endorses the paramount need to ascertain what caused the fire and to ensure that no such tragedy occurs again. Celotex is and has from the outset been committed to providing its full cooperation and assistance to this inquiry. To that end, Celotex has undertaken an extensive collation and review exercise to identify and disclose relevant documents in response to the inquiry's disclosure requests. Celotex submitted a detailed position paper in Phase 1 and has provided a substantial written opening submission for this module of Phase 2. Celotex's legal team has submitted detailed lines of questioning to assist the inquiry's legal team with their examination of witnesses to be called in this module. Celotex has also sought to respond to the fullest extent possible to the inquiry's requests for witness evidence from Celotex. None of Celotex's current management were involved in or have direct knowledge of the supply of insulation products that were used at Grenfell Tower, or of the launch or prior testing of RS5000, which was used as one component of the rain screen cladding system on Grenfell Tower. All of the decision makers responsible for the testing and launch of RS5000 and the supply of Celotex products to Grenfell Tower are no longer employed by the company. Celotex's current managing director, Mr. Dean O'Sullivan, only joined the company in May 2016 after Celotex insulation had been supplied to Grenfell Tower. Mr. O'Sullivan had no involvement in and has no personal knowledge of the supply of that insulation to the tower or of the testing and launch of RS5000. He nevertheless has provided a detailed witness statement giving first-hand evidence of relevant matters where that was possible, and where it was not, the appendices to his witness statement provide a detailed and frank account of relevant events from a review of documents disclosed to the inquiry. In addition, in response to the inquiry's requests for evidence from responsible decision-makers, Celotex has liaised with relevant former employees to facilitate the provision of witness statements from them to the inquiry. All of these former employees are separately represented and have provided in their witness statements their own independent account of relevant events. Sir, Madam, throughout this inquiry, Celotex has sought to engage with the inquiry in an open, constructive, and transparent manner. It has acted throughout this process with complete candor, not only towards the inquiry, but also as regards the disclosure it has made to regulators and the market. In the course of reviewing Celotex's business processes in the aftermath of the Grenfell Tower fire, Celotex's current management learned that there were differences between the cladding system that had been tested to British standard BS 8414 in May 2014, and the description of that system in the test reports produced by the Building Research Establishment and the marketing literature for RS5000. That was not previously known to the current management at Celotex. As soon as it was discovered, Celotex's current management set about investigating the matter. It promptly disclosed the matter to the market by a public announcement on Celotex's website. It drew the matter specifically to your attention, as well as the attention of, among others, the BRE, relevant regulators, and distributors whom Celotex knew had purchased RS5000. In addition, Celotex commissioned a full retest of the system as described in the 2014 test report and the RS5000 marketing literature. That system met the relevant standards. Celotex's current management is determined to engage with and learn from the past. To that end, a new technical director has been appointed and a number of other new appointments have been made to senior positions within the company, including that of Marketing Director. New quality control processes have been and are continuing to be introduced across the business under the oversight of a new quality assurance manager. In addition, the company is intent on improving training and skills across its workforce and is engaging with all employees to promote adherence to appropriate standards and values. The company is committed to continuous improvement in these and all other areas of its business. Turning to the issues to be examined in Module 1, Celotex has summarized its position on those issues in its written opening submission. Celotex has noted in that written opening submission the myriad of failings on the part of the designers, contractors, consultants, and building control inspectors that have been identified by the inquiry's own experts in their expert reports. By reference to the contemporaneous documents disclosed to the inquiry, Celotex has identified in its written submission the key matters that it believes need to be investigated by the inquiry in Module 1. None of the failings identified by the inquiry's experts were known to Celotex at the time of the refurbishment. They have only become known to Celotex as a result of the work conducted by the inquiry. Sir, Madam, I know that you have read Celotex's written opening submission. I do not propose to repeat the points made in that submission. The appropriate time for me to revisit those points in detail will be in closing submissions after the evidence has been heard. I also do not propose at this stage to take up undue time dealing with matters that are to be investigated in Module 2. That includes issues concerning the manufacture, testing, and promotion of Celotex's insulation products. Those matters are to be examined in Module 2, and the appropriate time to address them will be in submissions to be delivered in that module. Celotex will at that stage address in full and in proper context the criticisms that have been levelled against it by other core participants. However, in the light of comments that have been made in the course of this opening hearing, I wish to make the following brief observations at this point. First, Celotex RS 5000 was promoted and sold on the basis that A, it was combustible, and B, could only be used in a rain screen cladding system that met the alternative route to compliance under paragraph 12.5 of approved document B. That paragraph permitted the use of combustible insulation in a rain screen cladding system in a building over 18 meters, provided the system met the performance criteria in the BRE report entitled Fire Performance of External Thermal Insulation for Walls of Multi-Story Buildings, known as BR 135. Those performance criteria required the system to pass the BS 8414 test. Rain screen cladding systems incorporating RS 5000 did meet the performance criteria under BR 135, as was demonstrated by the rain screen cladding systems that were successfully tested by Celotex to BS 8414 in May 2014 and in April 2018. Compliance by RS 5000 with the performance criteria of BR 135 was also demonstrated by the tests conducted by the Ministry of Housing, Communities and Local Government in the summer of 2017 after the Grenfell Tower fire. Those tests showed that a rain screen cladding system containing PIR insulation and ACM cladding panels with an A2 core passed the BS 841 test and consequently met the requirements of BR 135 and approved document B. Now, so far as specification of RS 5000 for the cladding system on Grenfell Tower is concerned, any construction professional involved in the design and construction of a rain screen cladding facade at the time of the Grenfell Tower refurbishment would or should have known that BS 8414 is a system test and applies only to the particular system tested. That is made clear in BR 135. The relativity reference for BR 135 is BRE 00005555. That states at page 19, the classification of a system tested to BS 8414 applies only to the system as tested and detailed in the classification report. The classification report can only cover the details of the system as tested. It cannot state what is not covered. When specifying or checking a system, it is important to check that the classification documents cover the end-use application. That clear and specific warning about the need to check the system being designed and installed against the system tested and detailed in the classification report was again repeated on page 23 of BR 135. The same point was spelled out in clear terms in Celotex's product literature. That can be demonstrated by reference to any of the RS 5000 product guides, but by way of example, one can look at the rain screen cladding compliance guide produced by Celotex. That is relativity reference CEL 0000416. That guide made clear on pages 3 and 4 that a rain screen cladding system containing RS 5000 would only be compliant with the requirements of BR 135 and hence with the requirements of approved document B if the system matched the system described in the marketing literature. The compliance guide replicated in full the warning from BR 135 to check that the system being designed and installed matched the system detailed in the classification report. And that is clearly stated on page 3 of the document, at the top of that page, on the right-hand side. It is again repeated on page 4, again on the top of the page, on the right-hand side, the bottom paragraph in the column on the right-hand side, above the diagram. That is a warning to which the designers and contractors involved in the design and construction of the cladding facade on Grenfell Tower should have been particularly alert to, because it is also spelled out in approved document B. We don't need to turn this up, but the reference is Appendix A, paragraph 1 of approved document B in note 2. And that states in terms that any test evidence used to substantiate the fire resistance rating of a construction should be carefully checked to ensure that it demonstrates compliance that is adequate and applicable to the intended use. Small differences in detail may significantly affect the rating. This is a particularly important point in the context of Grenfell Tower, because it is abundantly clear that the cladding system designed and installed on Grenfell Tower bore no resemblance to the system described in Celotex's marketing materials. The evidence shows that the designers and contractors had copies of Celotex's product literature at the time of the refurbishment. They also obviously had or had access to approved document B and BR135. Despite that, none of them explain, whether in their witness evidence or their written submissions, how they satisfied themselves that the rain screen cladding system they designed and installed was compliant with the requirements of approved document B. They knew or should have known that the linear route to compliance under paragraphs 12.6 and 12.7 of approved document B was not available because the insulation they had chosen was not of limited combustibility. However, none of them explain what, if any, consideration was given by them to achieving compliance of the rain screen cladding system with paragraph 12.5 of approved document B and the requirements of BR135. Demonstrating such compliance was, I emphasize, a matter for the designers, contractors, and consultants. It was not a matter for which Celotex was or can sensibly be said to have been responsible. Celotex manufactures insulation. Celotex is not a designer, architect, or building contractor. Celotex does not install insulation on buildings and did not do so at Grenfell Tower. Nor does Celotex manufacture, supply, or install cladding systems, and it did not do that at Grenfell Tower. Responsibility for the design and construction of the cladding facade lay with the designers, contractors, and consultants involved in the Grenfell Tower project. It did not lie with Celotex. Celotex's sole role was as a manufacturer and supplier of insulation products. Those products were supplied through third-party distributors. Celotex does not, as a general rule, sell direct to end users, and its only contractual relationships are generally with distributors. That was the case for the Grenfell Tower refurbishment. Sir, Madam, in these circumstances, the stance which Ryden, Harley, and Studio E have adopted, whereby they seek to blame Celotex to the exclusion of themselves for the selection and design of a rain screen cladding system that was not compliant with the requirements of approved document B or the building regulations, is, in our submission, misplaced and unfounded. As I have said, Celotex acknowledges and accepts that there were differences between the cladding system that had been tested by Celotex to BS 8414 and the description of that system in Celotex's marketing literature. However, in the context of Grenfell Tower, those differences in our submission made no difference. Indeed, none of the designers or contractors suggest that they relied upon the description in Celotex's marketing materials at all. That is unsurprising, since the rain screen cladding system on Grenfell Tower was so substantially different to the system described in Celotex's marketing literature that no reliance could sensibly have been placed by any construction professional on the system described in the marketing literature to show compliance by the very different system on Grenfell Tower with approved document B. Indeed, Dr. Lane has said in her Phase 1 report, in terms, that the BRE certification of RS 5000 was irrelevant to the external wall construction of Grenfell Tower. That is Dr. Lane's Phase 1 report at paragraphs 11.22.11 to 11.22.12. Sir, Madam, when considering the claims made by the designers and contractors that they are not to be blamed for selecting the products used on the cladding facade, one must have regard to their knowledge at the relevant time of the fire safety hazards posed by those products. And in this regard, the evidence suggests that all of Studio E, Harley, Exova and Ryden knew at the time of the refurbishment that the cladding panels specified for use on Grenfell Tower would fail in the event of a fire where external flaming occurred. Now that appears from an exchange of emails involving those entities in March 2015. That exchange is referred to in paragraph 65 of Celotex's written submission. It arose out of a debate with building control about whether cavity barriers or fire stops were required in the rain screen cavity. And I would like to spend a few brief moments just identifying the key features of that exchange. And this requires looking at 4 documents. The first is a document, the reference for which is HAR 0006585. That is an internal email on the 27th of March 2015 from Mr. Anketel Jones of Harley to Mr. Ray Bailey of Harley. And in that email, Mr. Anketel Jones states, in the second line, "There is no point in fire stopping. As we all know, the ACM will be gone rather quickly in a fire!" exclamation mark. The next email in this train of emails is at SEA 000-13049. This is an email on the 31st of March 2015 from Mr. Crawford of Studio E to Mr. Ashton of Exova. And in the course of that email, and one needs to go to the middle of the document for this.
Sorry, just forgive me a moment. These documents are going to be published on the inquiry website, so you don't need to take photographs of them. Yeah, I'm sure you did, but I just thought I'd make that clear because I don't think it's right to be photographing stuff on the screens. All right. But it will go public later on today. Yes, I'm sorry, Mr. Orr.
Yes, sir. So in the middle of that document of that page is an email from Mr. Ashton of Exova to Mr. Crawford of Studio E, and in the final sentence of his email, Mr. Ashton says this: "Even if we were to agree with RBKC, it is difficult to see how a fire stop would stay in place in the event of a fire where external flaming occurred, as this would cause the zinc cladding to fail." And Mr. Crawford's response to Mr. Ashton the same day was as follows: "Hi, Terry. Thanks. This was my point as well. Metal cladding always burns and falls off." So the next document we need to look at is reference EXO 00001347. And this is an internal email within Exova from Mr. Pearson to Mr. Ashton. In this email, Mr. Pearson expressed the same point made by Mr. Ashton in slightly different terms. And he said in the middle paragraph of that email, "We would not rule out that fire could enter the cavity if there's flaming through the windows. However, if significant flames are ejected from the windows, this would lead to failure of the cladding system." The final email to note in this train of emails is at SEA 000-13051. And here we can see towards the middle of the document is an email from Mr. Crawford to Mr. Lawrence of Ryden on the 31st of March. And Mr. Crawford emails Mr. Lawrence and says, "Hi, Simon. This is the response I got back from Exova below." So he draws specific attention to Exova's email below. Seems like no one really agrees with John, that is John Hoban, the building inspector. So let's see what he comes back with after my last email. And Mr. Lawrence at the top of the page responds to Mr. Crawford, having been directed to Mr. Ashton's email, saying, "Excellent, that looks positive." Sir, Madam, whilst expressed in slightly different terms, each of Harley, Studio E, Exova and Ryden was openly acknowledging in these emails that the cladding would fail in the event of a fire with external flaming. That tragically is what happened on the night of 14th of June 2017. This email exchange shows that the risk which eventuated on that night was expressly foreseen by the designers, contractors, and fire safety consultants responsible for the Grenfell Tower refurbishment. This email exchange is also directly relevant to the claim made by Harley yesterday that they had no idea and no reason to believe that the principal materials used in the cladding facade would behave as they did in the event of a fire. The email exchange suggests the contrary. Harley, it appears, knew that the cladding would fail, indeed would fail rather quickly, in the event of a fire with external flaming. None of the individuals involved in that March 2015 email exchange have yet sought to explain how their knowledge that the cladding would fail in the event of a fire with external flaming can be reconciled with their responsibilities as designers, contractors, or consultants, as the case may be, to ensure or exercise reasonable care to ensure that the rain screen cladding system on Grenfell Tower complied with the requirement in the building regulations that the external walls of the building should adequately resist the spread of fire over the walls. This, we suggest, will be an important matter to be examined in the course of the evidence to be given in Module 1. Sir, Madam, the final point I wish to make in this oral opening concerns timing. Sir, Celotex and its legal team respectfully commend the care and diligence with which you and your team undertook the Phase 1 report. It will be necessary and indeed vital, we submit, to ensure that the next phase is conducted with equal and equivalent care and diligence. In Module 1 in particular, a large number of issues fall to be investigated with numerous witnesses. Those include issues of both a factual and expert nature. Many of them are complex and will take time to be explored with the witnesses. The legal teams for the bereaved survivors and residents have themselves identified that establishing the facts in Module 1 will not be a straightforward exercise given the quantity of material involved and will require careful questioning of the witnesses. They have also complained about the fact that in their view, the witness statements from the key players in Module 1 say very little. That makes it all the more important for the inquiry to conduct the careful questioning that the bereaved survivors and residents seek. It is crucial, we submit, that this process is not rushed or truncated. We do not invite delay. However, like the bereaved survivors and residents, we wish the inquiry to establish the truth and to formulate recommendations in which those affected by the fire, the construction industry, the emergency services and society as a whole can have full and complete confidence. That has, we respectfully suggest, been achieved by your Phase 1 report. If adjustment needs to be made to the current timetable to ensure that it is also achieved in Phase 2, that must, we submit, be in the interests of all concerned. Sir, Madam, as Celotex stated in its written opening submission, it stands ready to assist the inquiry in relation to Phase 2. On behalf of Celotex's legal team, I confirm that I and the rest of Celotex's legal team will do the best we can to assist you and your team. Thank you.
Thank you very much, Mr. Orr. Well, we're making very good progress for the morning. I think at this stage it would be sensible to have another short break. So we're going to rise now and sit again at 12:05, please. Thank you.
Hello, we are about to resume. Therefore, please can you take your seats and remain silent? Please can I remind you, no photographs are allowed to be taken in the hearing room and your phones should be switched to silent. Thank you.
Good. Now we're going to hear from Mr. Christie on behalf of CEP. Yes, Mr. Christie.
Thank you, Mr. Chairman. Madam, as you are aware, I appear on behalf of CEP Architectural FacadesLtd, instructed by Clyde & Co. Mr. Chairman, Madam, I begin by repeating that CEP and all of its employees extend their sympathy to all those affected by this tragedy and its condolences to all of those who have been bereaved. We appreciate, as was said yesterday, that those might sound like hollow words, but they are sincerely meant. This was a dreadful tragedy, and it has caused much suffering to many people, for which everyone feels immense sympathy. Can I also reiterate that CEP remains committed to providing its full cooperation to the inquiry to assist with Phase 2. To date, it has provided comprehensive and extensive disclosure of documents, and for the purposes of this inquiry, it has provided a total of 4 witness statements from 2 of its employees or former employees. These are Mr. Jeff Blades, its commercial projects manager prior to his retirement in 2018, and 2 witness statements from Mr. Neil Wilson, who is currently the company's general manager. Mr. Blades is, as you know, scheduled to provide oral evidence to the inquiry in due course, and we can assure the inquiry that he will endeavour to do so honestly and conscientiously to the best of his ability and recollections. Mr. Chairman, we're grateful to the inquiry for the opportunity to make oral opening submissions and for the allocation of half an hour in which to do so. In fact, I'm going to address you only for a part of our allotted time, probably only about 10 minutes or so. I'm going to cover 4 topics. First, I'm going to make a few comments about CEP as a business and a company. Secondly, I'll provide an overview of CEP's involvement in Grenfell Tower. Thirdly, I want to look at the key issues which have been identified in relation to this module and consider CEP's potential involvement in respect of each of them. And fourthly and lastly, I want to make some general submissions about CEP's position. Starting with my first point then, some short observations upon CEP as a company. CEP is a small to medium-sized manufacturing company based in St Helens in Merseyside. Up to 2017, it had about 25 employees at its premises there and a turnover of about £4 million. It manufactures, fabricates, and supplies materials to the construction industry, principally cladding and windows. The process of fabrication of cladding panels and windows is described in the first witness statement of Mr. Blades at paragraphs 12 to 13. But if I can just summarize it briefly as follows. As regards the fabrication of cladding, the process was typically as follows. CEP would receive an order from a purchaser to supply cladding panels of a specified type and with specified dimensions. The type of material would have been pre-selected by the designer, and the dimensions of the panels would have been set out in design drawings supplied by the customer. CEP would then have ordered the specified materials from the cladding manufacturer and cut them according to the required dimensions, folding them into the required shape where necessary. The fabricated panels would then have been dispatched to site. And the same process, roughly, applied as regards the fabrication of windows. There would have been an order by a purchaser to CEP to fabricate and supply windows of a specified type and dimension. CEP would in turn have ordered the requisite window bars from the manufacturer, and it would then have assembled them into a window frame at its factory before dispatching them to site. So in the typical case of an order for the fabrication and supply of materials, that was the extent of CEP's involvement. Now, it's true that on occasions CEP also provided a service, whereby it would not only fabricate and supply material, but also design the overall cladding system as well. But it didn't have the expertise to carry out design work internally, and so where it did take on any design responsibility, it had to subcontract the design work out to a subcontractor. Although there was some discussion involving CEP, Studio E, and Ledbetter in 2012 and 2013 about CEP's potential involvement in designing, manufacturing, and supplying a cladding system, and the discussions referred to the use of Raynobond, in fact, it never came to anything at all. And as you're aware, sir, madam, in fact, Ledbetter dropped out of the picture entirely. Equally, although Harley asked CEP to provide a quotation for the design and supply of a full cladding system in January 2014, again, that was never pursued. So I move on to my second topic, and that is to summarize CEP's involvement in Grenfell Tower. I can do so shortly because we've summarized the relevant events which took place in 2012 and 2013 in paragraphs 24 to 30 of our written submissions. The short point is, and I'm talking about that point in 2012-13 at the moment, the short point is that CEP was not engaged at any time during that period to design or supply anything at all in relation to Grenfell Tower. As regards the events from the beginning of 2014, these are summarized in Mr. Blade's witness statement at paragraphs 14 to 26. In January 2014, as I've indicated, CEP was asked to provide a quotation for the design of the cladding system, but that came to nothing. Following the appointment of Ryden in early 2014, CEP was copied into discussions about cladding. However, this was in the context where CEP was being considered as a potential fabricator. And it was in this context that on or about the 23rd of April 2014, Arconic circulated the BBA certificate for Raynobond panels, which Harley had requested Arconic to provide. In September 2014, CEP was asked by Harley to supply a quotation for the fabrication and supply of window frames. The type of window frame was specified by Harley. It was a specific type of frame manufactured by Metal Technology. CEP provided a quotation, and Harley sent a purchase order in November 2014. CEP fabricated the windows, and they were delivered to site between February 2015 and August 2015. So far as we're aware, they were installed by Osborne Berry. The position as regards the cladding panels is that in February 2015, CEP was asked by Harley to provide a quotation for the fabrication and supply of Raynobond ACM panels, smoke silver metallic Duragloss 500 satin. CEP supplied quotations in March 2015, and the panels were ordered by Harley thereafter. CEP obtained the materials from Arconic, and the panels were fabricated and delivered to the site. As you've heard, the original Harley company went into administration and CEP made further supplies of Reynobond ACM panels to Harley Facades during 2015. In summary, that was the scope and extent of CEP's involvement. It fabricated and supplied metal technology windows and Reynobond panels as requested by Harley. Mr. Chairman, the scope of this model was very helpfully set out in Annex B to the inquiry's letter dated the 30th of October 2019, and counsel to the inquiry has addressed you on it yesterday. But it is our submission that of the 7 key issues identified, 6 do not concern CEP at all. Just taking those very quickly, but in turn, CEP had no involvement in the initial decision to undergo refurbishment. CEP does not know the reasons why that decision was taken and cannot assist the inquiry on that point at all. By the same token, CEP was not appointed by the TMO and had nothing to do with the appointment of other professionals, nor of the procurement of the design and build contractor. It did not have any responsibility for planning or fire strategy, nor did it have any responsibility for building control. Now that leaves, of course, the very important issue of issue 5, which concerns the cladding and the design and selections taken in relation to it. CEP was, of course, as I've indicated, involved with the fabrication and supply of one part of the overall cladding system, namely the cladding panels, and it also fabricated and supplied the windows. But it had no involvement with any other part or parts of the cladding system, including insulation and cavity barriers. Further, it had no involvement in the selection or supply of window infill panels or window surrounds. So its involvement was restricted to the fabrication and supply of the component parts which I've indicated, the cladding panels and the windows themselves. It did not go any further than that at all. Importantly, CEP did not have any design or advisory responsibilities. So can I move on to my 4th and final section? We say there are 7 points which are critical to understanding the scope of CEP's role and the nature of its involvement. Now, sir, Madam, in making these submissions, we are not trying to downgrade the involvement of CEP or to deflect responsibility onto any other parties at all. We are simply trying to identify and delineate the involvement of CEP. And so my 7 brief points, Mr. Chairman, Madam, are these. First, CEP was never instructed or retained to design the cladding system or any part of it, or to advise on the suitability of any part of it, much less the whole. In the past, it had provided design services for some cladding systems, but where it had done so, it had to subcontract design to an outside design specialist. That did not occur in relation to Grenfell Tower, and CEP had no design responsibility at all in respect of any part of the refurbishment works. Secondly, CEP was requested by Harley to fabricate and supply specific cladding panels and specific window frames for the tower in accordance with the terms of Harley's purchase order. The purchase order stipulated that CEP was to supply Reynobond smoke silver panels and metal technology windows as detailed on certain drawings. That is what it did. Thirdly, CEP had no design responsibility whatsoever in relation to the selection of those materials, and it was no part of the responsibility of CEP to advise about the suitability of the products which it was requested to supply. Fourthly, the BBA certificate in relation to the panels which CEP was requested to supply stated that it was Class O, and CEP's employees knew that it was so classified. It would have been reasonable for any supplier to rely upon that certificate. As was said yesterday by Mr. Taverner for Ryden, the BBA certificate was intended to be relied upon by construction professionals on the basis that it contained accurate statements and information. And notwithstanding observations just made by Mr. Hockman, there was no reason for any supplier to go behind it. On the contrary, it was reasonable for a supplier to rely upon it, and it was entitled to do so. Fifthly, after the fire, CEP learnt that in 2015, an organisation called CSTB, French organisation, had classified riveted and cassette Reynobond PE panels as being Euroclass C and E respectively. CEP was unaware of the existence of those certificates prior to the fire. Sixthly, having been requested to supply the panels, CEP procured them from Arconic and then fabricated them according to the dimensions stipulated by Harley. That involved cutting the panels to the dimensions required and in some cases folding them. But critically, it had no further or more extensive obligations. It was the same with the windows. CEP obtained the relevant parts for the window bars and it fabricated the windows. Seventhly and finally, CEP supplied the panels as requested by Harley and they were duly installed by another subcontractor. CEP had no involvement in that part of the process at all. Mr. Chairman, Madam, that in a nutshell is CEP's position. Plainly, it had involvement in the fabrication and supply of the panels and the windows, but it had no design responsibility, no responsibility for selection of materials, and no responsibility for advising on the suitability of component parts, much less the whole. I needn't elaborate any further at this stage, but it's important from the outset that it is clear, we submit, that CEP's role was extremely limited. This is not to point the finger at anyone else at all. It's simply to identify the scope and limits of CEP's role. Mr. Chairman, those are my submissions.
Well, thank you very much indeed. Well, the programme for today did include provision for an opening statement to be made by Osborne Berry, the contractor which actually fixed the panels to the building, but Osborne Berry has decided that it doesn't wish to make an oral opening, and so we've reached the end of the programme for today, rather more quickly than I had thought we might, but perhaps one should never complain about that sort of thing. So we're going to rise now for the day, and we'll resume tomorrow with some further opening statements at 10 o'clock. I look forward to seeing you all then. Thank you.